Good morning, everyone. Good morning to those of you who attended last week. Today, we're doing two mishaps. We're doing number 4, which is not documenting and or proper discipline. So we're going to talk about that. And then we're going to talk about mishap number 5, which is some of the newest of the Oregon employment laws. And I've just been helping a member the other day, and I looked at their handbook, which we talked about last week, and I see that none of this has been captured in this handbook. So let's talk about mishap number 4, which is no documentation. There we are. No documentation and discipline. So we hear from supervisors that say, I want to discipline, I want to terminate this employee. They're not a team player, they don't do their job. And then we ask at CIS, well, great, do you have any documentation on poor performance? And they're like, well, no, not really, but he's a really bad performer, or the employee's a bad performer. And then we find out, well, the employee just filed a work comp claim. So no, you're not going to just go discipline and terminate this employee. So how do we do this? It's huge. As managers, you've got a lot going on, and oftentimes the question is, well, how do I go about doing it? So I like to follow the 5 W's. Who, what, when, where, and why. And as a manager, if you put this up on your little board, who, what, when, where, why, it really helps you stay out of the muck when you're trying to find out what's going on. So the first W, who. We want to find out who's involved. Is it just the employee who's not doing their job, or are other employees affected? Maybe you have an employee who's supposed to be entering data in the system and they're not doing it on time, and it affects another employee who needs to run checks. So who is involved by this employee's poor performance? 1 person, 2 person, 3 person. Who has firsthand knowledge? So you want to identify who. The next thing you want to identify is what. What was said? What happened? What policy and procedures have been violated? If you have a collective bargaining agreement, what articles have been violated? So we're going to find out the what. Very important at this point that you're not interjecting your personal opinion, okay? Next thing is going to be when. When did it happen? Is it still happening? So is this a routine thing that Sally can't get the data entered on time to run the checks? Or did it happen just once or twice? So when? For other kinds of conduct, did the conduct happen during working hours, off duty? So what was the date, the time, the month? That's all very relative information. So when? Where? Where is this conduct occurring? Is it happening in the office? Is it happening in a city-county pickup truck? Is it happening on a taxpayer's property? Maybe the inappropriate conduct that we want to discipline was happening out on a citizen's property. So where did the conduct take place? We also want to identify here how often the conduct is taking place. Then we want to know why. So this is where we're going to interview the employee. We want to hear from the employee their version. So by asking the open-ended question of why, the employee is telling us their side of the story. This is very important for you, the supervisor, or the person collecting the data, to remain unbiased and not give your personal opinion. Because I talk to so many managers and they're like, well, this is what the employee did. And you're like, what did you ask the employee? They're like, no, but I know this employee. This is what's happening. This is the reason why. Well, let's ask the employee their side of the story. So we don't want to give our 2 cents. We don't want to speculate. We want to collect the correct information. Okay, progressive discipline. We talked about last week, perhaps having a progressive discipline policy, or at least an outline in your employee handbook. If you have a collective bargaining agreement you're using, you probably have progressive discipline in the collective bargaining agreement. So before you write up your discipline, or before you decide what level of discipline you're going to give, take a look at your policy. Take a look at your collective bargaining agreement, okay? So it may say that you give an oral warning, or you may go straight to a written warning. Maybe there's a first, second, or a final written warning in your language before you can do leave without pay or termination. So you notice I don't have coaching up here. I do not see coaching as a level of discipline. Coaching, managers, is what you should be doing as part of your job. Coaching is not discipline. If we coach our employees as we go, if we have one-on-ones with our employees, our direct reports, about how they are performing their job, oftentimes we can nip the situations that the employee is not doing well. If we are coaching and counseling our employees, oftentimes we don't need to get to discipline. I find that the supervisors who want to go right to discipline are the supervisors who are not working one-on-one with their employees. They just let the employees go out, do what they're doing, then they get frustrated because another employee is telling them Sally's not doing their job, or whoever. And now all of a sudden they've had enough and they want to go discipline. They want to go right to written warnings. Well, supervisor, where was your coaching and counseling? All right. So before discipline occurs, of course, we're going to take a look at all the facts. We're going to look at our who, what, when, where, and why. We're going to look at the seriousness of the infraction. This is an area that we want to make sure we're not treating one employee different than we've treated a similar employee in this situation. This is oftentimes where an employee screams discrimination. You were very harsh and you gave me a written warning, or you're trying to terminate me, yet your buddy over here, you gave him a verbal warning, or you didn't give him a warning at all. And so we really want to take a look at what are the facts, what's the seriousness, and was the employee even aware of the work rules? This is where we go back to that new employee orientation and during performance evaluations, where, you know, it's a good idea to revisit our city and county rules. If the employee is having a problem on attendance, why don't you go over the policy about attendance with them, okay? So was the employee coached, advised, warned? Did we re-educate the employee? Is there documentation of other performance issues? So you may not be able to go straight to a written warning if it's really more of a first offense and we should be really doing an oral warning. So we really want to take a look at the seriousness and to see if there's been discipline prior to. Okay, and again, how have other employees been disciplined on something similar? Okay, how do we write a warning? Well, first off, you want to put the date, okay? You want to put the date on the warning, and then you want to identify what kind of warning this is. Is it a verbal warning? Is it a written warning? We start our warning by identifying what policy, procedure, collective bargaining agreement, article has been violated, okay? This gives us some meat to our warning. All right, so you might say that Article 2 of the collective bargaining agreement on attendance was violated. All right, then we want to give examples. What did the employee do? When did they do it? Well, you might say on March 5th, okay? Or on these dates, March 5th, March 6th, March 9th, March 10th, whatever. Now we're going to say what they did. You came in at 9 o'clock, you know, and you're supposed to come in at 8 o'clock. So what did they do? Then we want to say, what are you supposed to do? So you've been arriving at 9 o'clock. Those were unapproved start times. What you're supposed to do is come in at 8 o'clock a.m. in order to open the city hall, okay? So give examples. State the policy, procedure, collective bargaining agreement that they violated or that you are referring to. give examples, what they did, what they're supposed to do, and now what's expected of them ongoing. You are to report to City Hall to open the office at 8 o'clock every morning, go on and on and on, okay? You might also want to put in here what's going to happen if they don't do this. So you might put a clause in that says, you know, this is your opportunity to correct these performance issues, failure to adhere to the conditions of this verbal or written warning may result in more serious corrective action up to including termination, or something like that. You know, we could help you with some language, but you want to let them know what's going to happen if I don't correct my behavior. All right, we have a chat. Question: are annual evaluations outdated? Would more frequent informal evaluations benefit the employee or employer? If there are issues with the employee, how do you recommend they be addressed in an evaluation? Okay, great question. So here's what, whoops, just a minute. I gotta find my little marker. Okay. First of all, what I think helps is ongoing one-on-ones with our employees. When we look at performance evaluations, we do want to grab in the performance evaluation conduct of the last year, right? But a performance evaluation should never be the first time that an employee finds out that they have not been doing their job up to standard, all right? The employee should never go into a performance evaluation and find out, oh my gosh, I didn't know I was doing this right, okay? We do want to capture any behavior that we've been talking to the employee about in the last year. So if you have a verbal warning, a written warning, we do want to wrap it into the performance evaluation. But managers, if you're doing one-on-ones with your direct subordinates, at least a minimum of once a month, you should be able to catch poor performance during this time. Now, sometimes that's not working. You're doing the coaching and counseling, and then you need to write the warning. So you want to write the warning, okay? And then again, when you go to do the performance evaluation, you're going to tie this in. Even if they're doing great, you want to say, you know, in March, you did get a written warning for blah, 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 blah. You've been doing a great job. You know, you're continuing to improve, blah, blah, blah. So you do want to capture that warning in the performance evaluation. Okay, clicker, why are we not clicking? Oh, here we go again. We're going to have a little technical difficulty here. There we go. All right, mishap number 5. Employment laws, Oregon employment laws. There we go. So, discrimination. We know that at the Oregon and the federal level, there are various categories of discrimination or protected classes, all right? So we have protected classes for race, religion, national origin, pregnancy, discrimination against sexual orientation, family unit, filing a workers' comp claim. There's all sorts of protected classes, both identifying who we are as an individual, your race, your religion, your national origin, your age, your sexual orientation, and certain things that we are protected to do, such as file a work comp claim, go out on protected leave, all right? We have all of these categories, both under the federal protections and under the Oregon protections. An employer may not refuse to hire or not to hire, to terminate, not to terminate, to promote, not to promote, based on an individual's protected class, okay? So none of these categories, these protected classes, may come into play when we are making employment decisions. Another reason why discipline documentation is so important, because if you're not documenting your discipline and then you go and discipline an employee and there's nothing that this employee knows that they've been doing wrong, they're going to come and say, you know what, I think you're disciplining me because you want to get rid of me because you found out I'm of the religion of XYZ, and I know you don't like people of that religion. So your employee will come up with a reason, a discriminatory reason for the why, if we don't fill it in. Okay, so let's talk about protected law under the Oregon Pay Equity. So this was effective January 1st, 2016. We talked about making sure that you have a policy in your employee handbook. I believe this was the first Oregon law that said it must be in a handbook. Before, handbooks were really about an organization's policies and procedures, but Oregon came in and said, hey, make sure this law is in your handbook. So what does it say? Well, it says that all employers with one or more employees in the state of Oregon must have this law. It provides equal pay for equal work unless there's a bona fide reason. We're going to talk about that in a minute. It also says we can no longer consider salary history when deciding whether to hire someone or trying to figure out salary for an applicant, all right, at the very beginning. That's why when we talked about applications last week, we said take the salary information off your application, okay? So here we have protected class. We just talked about discriminate categories of protected class. This pay equity law of Oregon refers to all of these when it comes to how we are bringing an employee into the organization, how we are going to pay them. So this law prohibits discrimination based on any of those protected classes, okay? I remember talking to a city manager about pay that he wanted to bring this male employee in at a higher rate than anyone else, okay? And I talked to him about that. And I says, well, you can't do that. And then we started talking about the past history about bringing employees in at different rates. And he told me, he said, well, Sharon, you know, I think males are just better at negotiating a starting rate than females were. Oh my goodness, there we go. No, we're not going to do who negotiates better. Exactly why we are perhaps in this situation where some people have been brought into a position at a higher rate based on who they are, maybe based on their sex or their gender. I talked to another chief one time who was bringing 2 employees in, 2 basic police officers. He was hiring at the same time. He had 2 openings and he was going to hire these 2 employees. One was a female and one was a male. Well, the female, she was single. He thought, well, I'm going to start her at step 1 of the hiring schedule. But he wanted to bring the male in at step 3 because he had a family. And, you know, he needs the money because he's raising a family. No, this is exactly why we have this law, all right? Now, when we're looking at the Oregon Pay Equity, we do want to look at positions that we have. And we want to look at not just job titles, we want to look at the substance of the job. So we want to look for positions of what we call comparable character. We're going to take a look at the knowledge, skill, effort, responsibility of the job. We're going to look at the working conditions, all right? We're going to compare similar jobs based on some of these characters, not just the title of the job. Now, there are some reasons, sometimes, when you can bring an employee on board at a higher rate than another employee. And these are going to be what we call bona fide reasons, all right? So maybe you have a collective bargaining agreement and you are going to, through your seniority system, raise somebody's pay higher than somebody else who's doing the same job through a seniority system. That is fine. Maybe you are going to hire someone who has more education, maybe more training certificates. So maybe you're hiring a wastewater operator and the job requires an wastewater operator 1, but the applicant you're hiring has a wastewater operator 2 and 3, and you're like, wow, that we can use. We can use somebody with those certificates. So you bring that person in at a higher start rate because of these certifications, all right? Maybe you have people who do similar jobs, but one person has to travel more to do their job. So there's something about that job that allows that person to receive a higher pay. Of course, we have this all documented. We don't just want to wing it. It's going to be documented. This is the reason why we are starting employee X at a higher rate than we started employee Z. Okay. How do we go about this? Well, we've been talking since 2016 about doing an equal pay analysis. There's a lot to this. Some people are hiring outside agencies to do it. You can do it internally, but what you want to do is you're going to determine which employees are performing work of that comparable character. Okay, so again, knowledge, skills, abilities, responsibility, what's the guts of the work, not just what their paid title is. Then we're going to look for any compensation discrepancies between these groups of people, okay? Then we're going to look for the bona fide reasons. Is there a true reason why employee X is paid more than employee Z? Yeah, employee X has 4 certifications and employee Z doesn't, okay? So we can look at that. If we find people of comparable work character, and we did not find any reason, any bona fide reason that one employee is paid more than the other, then you need to fairly compensate, which is probably bringing the employee of the lower pay up to the higher pay. So in order to comply with this law, you might want to do an equal pay analysis. This is something that CIS does not do. It's compensation, and we do not do compensation surveys, just to put that out there in case people start asking in the chat if we'll take care of that for you. Okay, another Oregon law, 2020, should be updated in your handbook, is the new Workplace Fairness Act. So we've had harassment laws in our policies now in our handbooks now for a number of years, but this new harassment law of 2020 has gone deeper, all right? So again, if you haven't updated your policy yet and you're a CIS member, you can go out to the 2020 CIS Employee Handbook and you will find a sample in that handbook for this law. So one very important issue about this is the new statute of limitations. It went from 1 year to 5 years for someone to file on discrimination, harassment, or any other retaliation claim under these ORSs. And you see ORS 659.030 is about a protected class. How many protected classes are there? There's a lot. Religion, race, sexual orientation, gender, okay? So there are a number of them. The policy needs to have a statement prohibiting workplace harassment. Your policy needs to provide for a very clear complaint reporting procedures, okay? You need to make sure you have a no retaliation provision in this policy. And then something new is that you need to identify at least 2 people in your organization who can receive complaints. Now, when this opened up, many people said, how do I do that? Our recommendation is identifying titles. I wouldn't identify the employee's name like Mary Jo, HR director, because Mary Jo might retire someday. So you might want to just do the title of the HR director or a city manager or a county administrator or county council, whoever your people are. You need 2 people. These 2 people need to be trained and very adverse in what a complaint might look like. Because one thing we don't want to do is to allow our unconscious bias to come into any potential decision on whether you have received a complaint or not. Many people, because we know our employees, we kind of make our own decisions about, is this really a valid complaint, or is that just Sally? She just tends to complain about a lot of things, and I just think that's what she's doing. No, we need to take all potential harassment complaints very, very serious. So we need to have 2 people identified. That does not mean that those are the only 2 people that employees can go to. An employee may still go to any supervisor in the organization that they feel comfortable going to bring a complaint of harassment or discrimination or retaliation. It's just that under the policy now, at least 2 people must be identified. Okay, something else in this is the policy must be in writing and must be made available to all employees in the workplace. So you need to give a copy to all current employees. You need to give a copy of this policy to each new employee at the time of hire. And you want to give a copy of this policy to an employee who discloses information of protected discrimination or harassment, so they know what their rights are. Okay, the next law I'd like to talk about is also January 1st, 2020, which is the accommodation for pregnant employees. This applies to all employers with 6 or more employees. The effective date on this policy was January 1st, 2020. And what it says is that you must provide a reasonable accommodation to employees and applicants who can't perform all of the essential duties because of the known limitations caused by pregnancy, childbirth, lactation, or related medical conditions. So what's a reasonable accommodation? Well, maybe it's allowing an employee a longer rest break, or assisting with manual labor, or making accommodation of equipment. I worked with a county right before this rolled out, and it fit very nicely. They had a female whose job assignment was to go to families' homes. So I don't know if it was in the juvenile department or one of the public health. Anyway, don't remember what department, but this employee was charged with driving a county car, and I think they had like Ford Focuses, so these small county Ford cars, and they drove those to the site locations. Well, this employee was in her last term of her pregnancy, and she's getting kind of big, and she was having a hard time fitting in the vehicle. So by the time she pushed the seat back, she couldn't reach the gas pedal and the brake. So she thought, unsafe. So she came to her manager, and her manager said, oh, well, our policy is that you have to drive a county car. And so they called me, and I said, well, gee, do you really have to abide by that policy right now? Oh yeah, that's our policy. And I said, well, you have 2 choices. Is there another car the employee can drive, like a pickup truck or a van? They're like, oh, only our public works guys have pickup trucks, and they're not giving up their pickup trucks. I said, well, then you know what? You have a choice. The employee is obviously getting to work in her car, and they said, yeah, she drives a minivan. Great. You know what? Make an accommodation. Allow the employee to drive her vehicle during this last trimester. This isn't going to go on forever. When she comes back, she'll go back to driving the Ford Focus. Okay, perfect accommodation. I get the policies, I get the rules, but this would be an appropriate accommodation in order to allow the employee to do the essential functions of her job. Okay, with this law, you have to post signs that tell employees about their rights under the law, okay, including the right to be free from discrimination because of the pregnancy, childbirth, or related medical condition that is and therefore the reason why the employee is asking for a reasonable accommodation. So the employee is protected. Please do not discriminate or treat the employee different because she has asked for this reasonable accommodation. Employers, you need to provide a copy of this policy to all new employees at the time of hire. Okay, and that's from January 1st, 2020. So if you hired anyone January 1st, 2020, that new employee should have gotten a copy of this policy. And make sure that all employees of your organization have received a copy by January 29th, 2020. So we're into July, so I'm assuming that all of you have given all of your employees, new hires and existing employees, a copy of this policy. When an employee informs the employer of their pregnancy, within 10 days, employer, you need to give them a copy of this policy again. All right, let's talk about the new family leave law. I believe it's called the Family and Medical Leave Insurance Program, FAMLY, that is coming 2022 and 2023. This is going to be a high-level review because we don't have all of the procedures yet. What I understand at this point is that the employment department is the one who is going to be administering this, and they're supposed to have everything out, the rules of how to administer this by September 1st, 21. That's my understanding. So, reasons for taking paid leave starting the year 2023. This is going to be paid leave to bond with the child, to care for a family member. We're going to talk in a minute the definition of family member with a serious health condition, or to take paid leave for the employee's own serious health condition, and for leave under the Safe Leave for Victims of Domestic Violence. You notice that this is kind of sounding like OFLA, right? These are protected things under OFLA. We already have job protection to care for a family member for a serious health condition, to go out on your own serious health condition, to bond with a child. But now, starting 2023, these categories are going to be paid. But under OFLA, not everything is going to be covered under the paid category. So we currently have under OFLA bereavement leave. That will not be a paid category. Sick child leave for that non-serious health condition that we have, all right? That is not going to be paid under this law. Or the Oregon Military Family Leave component. That will not be covered under the paid section. Still covered under OFLA, okay, but not covered under the paid medical part. So definition of family member. Okay, this is where things might change a little bit. We already have the employee, spouse, or domestic partner. We already have the child, stepchild, parent, sibling, step-sibling, grandparent, grandchild of the employee or the employee's domestic partner. Okay, but here's the new one. Any individual rated by blood or affinity. Not exactly sure what the word affinity is going to mean. It's someone who has a close association with the employee, so someone of equivalent of a family relationship. This is going to be the hard one to define because all the employee, I guess, has to say is that this person is my family. This person's like a sister to me, or this person's like a mother to me, so like a parent to me. So, you know, this is going to be the newer category that we are going to have to administer. I'm sure we will get some more guidance to help us through that definition. Okay, the length of this leave law. So the paid leave is going to be 12 weeks, all right? Now, we have those other categories of OFLA that are not part of this paid leave. So the employee's going to get 12 weeks of paid plus up to 4 of the other categories of OFLA that are not paid. So at this point, an employee could get 16 weeks, and then there's 2 more weeks for leave of limitations related to pregnancy, childbirth, or related medical condition, a potential another 2 weeks. So here we have the stacking that could get up to a grand total of 18 weeks of benefit in a year. I think most of your administration is going to be managing the 4 weeks of non-paid OFLA leave and the 12 weeks of the paid leave, so potential looking at 16 weeks of leave for an employee under this particular law. So employers, well, employers that have more than 25 employees, you're going to be required to make contributions. Employers with fewer than 25 employees will not be required to pay the contributions. All these employees are going to go into a fund, and all of this is going to be administered by the Oregon Employment Department. So stay tuned on that. I believe you're going to start making payroll contributions sometime in January of 2022. We should have other rules by September 1st of 21. Again, this is a high level. Stay tuned. I'm sure CIS will be doing more webinars in the future on this particular law as we begin to roll it out. So, went faster today on this one. Let's go into the chat box because I think I saw a question. Let me pull it up here. There it is. Okay, when we implement these new policies, do they typically need council approval or can staff just implement them? So for these policies that are laws, you need to implement them. The council can't decide whether you are going to implement one of the Oregon laws that you actually already have to be administering it. Now, I do know that many entities will take their handbook in front of city council to adopt a new version of a handbook. If that is your council rules, that's what you do, then of course follow your council rules. But the city council can't say, I don't want to put the Oregon sick leave law in our handbook, or I don't want to update our new harassment policy. I think what we have is just fine. These policies must be up to date, and there is very specific language that should be included. So again, if you are a CIS member and you have access to our CIS toolbox, go in there, find the handbook, find the 2020 version, and you can pretty much cut and paste the language that we have because it has been well written. Tamara Jones, our pre-loss attorney, Pamela Bowles, our HR analyst, has worked very hard on updating this handbook and giving a cheat sheet on the front of the handbook that says exactly what was changed in the 2020 version so that you know you are getting exactly what you should be changing. So update your handbook with these laws, go to our 2020 version. Need to take the handbook in front of council to get it approved, fine. But for the most part, you got to have these policies in your handbook. And like I say, I was just helping a member the other day, and none of this is in there. Pay equity happened in 2016. So we really want to get these updated. Here's another question. I'm not sure where to send this. I cannot find the toolkit, and our city is covered through CIS. Okay, out on our website, go to Employment Risk Management. So you can go to Risk Management tab, then Employment Risk Management tab. Then you should see the H2R Toolbox link. Open that toolbox link, and then there are categories, and I believe there's a category called policies and procedures. It may even say employee handbook, but that is where the handbook is. If you can't find it, contact me right after this training and I will help you out. Okay. Any other questions coming in? Don't see any other questions coming in. All right, Do we have any questions from last week? Oh, something, last week we ran out of time. We were talking about handbook. We were talking about personnel files. We were talking about job descriptions. I'm going to do mini webinars on all of these specific topics. So they're only going to be, you know, about 15 minutes long, 20 minutes long, maybe depending on the topic. And we're going to get those taped in the next week or so, and then they'll be out in the CIS Learning Center. So if you had any questions about or wanted to revisit those specific categories, I'm going to do a webinar. You can go out to our Learning Center and you can just listen to that one all by yourself. Next one, can we please get a copy of your slides to share with the rest of our HR team? Yes, my understanding is that Lisa will be making the whole entire PowerPoint presentation last week and this week put together. So you may get a copy of that. Another question, when using the term paid leave, can be confusing. If the employee needs to be gone for 10 weeks of qualified leave, however, only has about 6 weeks of accrued leave built up, that doesn't mean the city is required to pay the remaining time, correct? Okay, if we were talking about protected leave, let's say the employee is protected under OFLA. All right, and the employee has 12 weeks of paid leave but only needs 10. They're protected by law for that 10 weeks. If they only have 6 weeks of paid, well, then they're going to use their paid leave. Those other 4 weeks may be non-paid but still protected if they're under the law. Okay, if you are an employer under 25 employees, so you do not follow OFLA, I strongly suggest that you write a policy for your entity about how to tackle paid leaves, because many employers will call us and say, we only have 20 employees. We don't have 25. What do I do? And I say, well, what does your policy say? And they go, we don't have one. Ooh. Well, we're going to run the risk of treating people different. So if you're under 25 employees, go ahead and call us. We can help you create a policy for an employee who needs to go out on leave for perhaps a serious health condition. What is your policy going to say? How are you going to tackle employees going out? What are you going to approve it for? What term? Do they have to be in a paid status, non-paid status? So those are things that we want to help you do. Okay, let's see. Great, thank you for answering my question. You've got it. Can a copy be posted to CIS Learning as well? A copy of the training? Lisa, we will ask her that question. Next question, can we keep copies? Oh, let's see, whoops, it went up. Can we keep copies of DPSST F4s in personnel files for police officers? They contain personal information. Okay, no, not in the personnel file because they contain personal information. So remember, when we're talking about personnel files, we want to split the employee in half. Personnel, personal. Any document that has personal information, Social Security, date of birth, for the employer or the family members, we want to place in a confidential file. So you're going to take that DPSST F4 and you're going to put it in a confidential file for that employee, not in their general personnel file. Great question. Next, can you discuss the difference in the paid leave laws between the public and the private employees? Well, how much time do we have? You know, we only concentrate here on what we need to do for a public employee. You know, private employees also have paid leave laws. But we're concentrating on the public laws. So the laws that I've covered today are laws that you as a public employer need to administer for your employees. I don't want to get off onto a different track because I don't want to get our public employers confused with what they need to do. So if you want to go offline, we can talk about that. Sorry. Next question. Looks like nothing's coming in. We still have a little bit of time. What else do you want to talk about? We have a couple minutes. Thank you. Okay, great. Amy, thank you. Can we get those? Where can we get those signs? So posters, Boley has updated posters. Okay, for posting. So I would just go out to Bully. Oftentimes you can print things right off the Bully website. I would probably get things from Bully and not things that you have to pay for. So usually you can just go online and print something off. Will the recording be available to us? Yes, my understanding is that both the PowerPoint and the recording Lisa will be making available once it is ready to go. Okay, thank you. Perfect, Kim. These sessions were great. Thank you. Thank you, Melissa, for participating. How do we calculate protected leave? Days versus weeks. Are weekends included in counting days? So if we're talking about OFLA and FEMLA, we are talking about the days the employee worked. So if the employee works on a weekend, we're counting that. So we're talking about protected leave of how many days the employee would work. So if they work Monday through Friday, you're counting Monday through Friday. If they work, Tuesday through Saturday, then that's what we're doing. So you're not counting every single day of the week. We're only counting the days that the employee would work. Great question. Okay, Michelle, good to see you or hear from you. Any other questions coming in? These are great questions, everyone. Helpful for everyone to hear. Okay, here's another one. I'm glad to know we don't have to take policies to the council. Okay, I often wondered about that. Can you explain again what the fund is for under the new Family Leave Act? So as you know, this is going to be a paid leave. And so there's going to be a fund created where monies, depending on your size of your employer, you will be contributing to this fund. Employees will also contribute to the fund, and Oregon Employment Department will be administering it. So you are going to be getting more information in 2022 about how to administer the fund, okay, or how you are going to have to make your contributions. So again, if you take policies to council, take it to council to get it, the handbook or the policy blessed, but they have to do it if it's a law. They can't say, no, I don't want to update the policy. Oh, okay, just a minute. There's one that went a little bit higher. Hang on here. Okay. Don't miss the 5th LOC webinar on labor impacts of the police defunding movement. Yes, excellent, Diana. Here's another one. We were scheduled for supervisor training here in March and it was canceled. Yes. Do these 2 webinars cover what was to be in that training, or is this something else in the Learning Center? Well, I don't know. If you're talking about a supervisor training that I was going to do, this is probably a different PowerPoint. If it's something that was going to be covered by LOC, I'm going to have to let Lisa tackle that. Here's another one. Do personal and personnel files need to be located in different file cabinets, or can they be in the same file cabinet, maybe just a different drawer? Excellent question. If you only have one filing cabinet, fine. Make sure they are in separate drawers. If you have more than one filing cabinet, I like to move confidential files into a completely different cabinet. And that is so we don't pull the wrong one. So I also color coordinate my files. I make my medical files, work comp files be red, my personnel files one color, my maybe payroll benefit files be blue. So I color code them. So if we see a file's been put in the wrong drawer, we can correct that. So Confidential files, completely different cabinet. If you can, make sure it's locked, okay? If you only have one cabinet, put them in separate drawers. Do not put them all together. So if I have a file, you should not have my personnel file and my medical file all back to back. They need to be separated. Great, great question. Another question, would the employee have the option to opt out of contributing to the new family leave fund? I don't have the answer for that yet. Stay tuned. Oh, it was CIS. Okay, so if that's probably the training that I was going to do, is that Julie? No, it's not the same one. We will talk and we will see what we can do for you. Since I'm not able to travel yet, I am starting to do some trainings through a virtual format. So if that's something, if you're a CIS member and I was supposed to do a training for you and we can't and you want it sooner than later, we might take a look at doing a virtual format for you. Can the medical, work comp, and benefit files be combined? Yes, you may. You know, our smaller employers often put all of the confidential stuff together. That's perfectly fine. I tend to find our larger employers separate that out. Some is because maybe a completely different employee does workers' comp than who does payroll or benefits or other HR. So it really depends on your organization. The key is they are confidential and they are locked in a locked cabinet. Just a comment, your HR audit that you did with me a couple of years ago was extremely helpful. Thank you so much. And my personnel files still remain organized and separated. I highly recommend this for anyone needing help. Thank you, Susie. I'm so glad that that is still working out for you. I offer that as a CIS service. I can come and help look at what your files look like and help you get organized. Absolutely, that is something we'll do. Well, with COVID, I'm going to have to wait a little bit, but that is definitely something that we can help you do. You know, back in when I started HR, we had one file. I needed two hands to take the file out of the cabinet and everything was included. Takes a while to separate them out. Next question, can you explain administrative leave? Does a written notice need to be given to reinstate an employee who was on administrative leave? So, administrative leave is a big bucket. How did we put the person on administrative leave? Did we put them on a paid or unpaid administrative leave? If we've put them on administrative leave because of an investigation, so it's about potential discipline, we do need to notice the employee before we put them out on paid or non-paid administrative leave. So if you are in that scenario, please call CIS if you are a CIS member, and we will step you through the process of noticing an employee who may be put on paid or non-paid administrative leave. Yes, we certainly don't want you to get in trouble with that misstep, all right? Another one, I second Susie's comment. I appreciate your time walking me through some HR components. Absolutely. That is what we are here for. And some of the fun about my job is going out and working with members and helping them get reorganized. You all have a lot to do, I know. So the more that anyone from CIS can help you get yourself teed up, that is what we are here for. Absolutely. Reach out to us. Again, if you need it live, we're going to have to wait a little bit until we get released to go out and about. Can you explain in more detail which payroll records belong in the confidential file? So when you run payroll, most entities have a payroll file where when you've run your payroll, you are placing those documents. It's confidential because that payroll record may have information pertinent to the employee. So maybe your payroll records don't have social security numbers anymore, but maybe it has direct deposit information. So, you know, that payroll record, wherever you file them, is considered confidential. So again, many finance departments keep the payroll records. Those are confidential. We're keeping them in the finance department. Those records are not available to anyone who wants to see them, all right? Now, that is different than an employee's pay. What an employee's salary is public information. And that might be on a PAF, which is in an employee's personnel file. But their actual payroll, what they have coming out, where their direct deposit is, that is confidential. So Melissa, if finance keeps it, that's fine. You know, the thing about the payroll confidential file is some entities like to throw benefit information in there, and because they only want one file, that's fine. Again, other entities split all of this up. All right, so when you run your payroll, those are the records going in there. If you need more specifics, Melissa, give me a call. Okay. All right, again, you need more specifics, give me a call. You know how to find me, 503-763-3843. Shoot me an email, sharris@cisoregon.org. Love to talk to you all, miss seeing y'all in person. So let's see, any other questions? We have 4 minutes. Great questions. Great questions. Looking at the chat box. No? Thank you. Have a great day, everybody.